I'm sure your lordship would certainly agree with me in view of the settled legal position that 120B is certainly not a standalone offense. It is not a standalone offense. That is how your lordships and the Honorable Supreme Court has laid down the law that section 120B is not a standalone offense. Conspiracy. Conspiracy is for the commission of a crime. Well, if there is no evidence for the commission of the crime, a conspirator cannot be held. He can't be held liable under 120B in the absence of the proof of the commission of the crime. With regard to the commission of the crime, 1 to 6 are exonerated, 7 to 14 there is no evidence, zero evidence, because all these 7 eyewitnesses, so-called eyewitnesses, having not supported the case of the prosecution. My lord, what is the evidence against me then? Motive. I had a motive to do away with the life of the deceased. Well, the motive that is projected is that the deceased was a member of the Jilla Panchayat. But at this point of time, it would be useful for me to submit to your lordship that I was a 3-time legislator, a minister, chairman of a board holding cabinet rank. My grandfather was a barrister in London. It was he who established a law college in Dharwad. But it was he who appointed Dr. B.R. Ambedkar as a lecturer in the law college. That is how it goes, evidence goes, evidence goes. It is he and my family that donated hundreds and hundreds of acres of land for the poor and downtrodden. Why I am submitting this is on the basis of the evidence on record in the case that I hail from a cultural family. But without even stepping into my constituency, consequent to the order passed by the apex court, while granting the benefit of bail, that I should not step into that place, I won the election in 2023 with a margin of 1 lakh and odd votes. That is my popularity. That is how I am known to the people of my constituency. More than 1 lakh vote without even stepping into my constituency. The motive that is projected by the prosecution is a Jilla Panchayat member. If he is allowed to grow further, one fine day, if not today, after a couple of years, he will throw a challenge to my political career, is the motive that is projected by the prosecution. But for that, they would narrate one incident. That is, 2 months prior to this incident of assault on the person of the deceased, that is on 15/6/2016, there was a Jilla Panchayat meeting. To be more precise, it was on 23rd of April 2016. On 23rd of April 2016, there was a Jilla Panchayat meeting. But that Jilla Panchayat meeting was convened by the Chief Executive Officer, who is an senior most IAS officer, as in his capacity as the CEO. The participants in that meeting being the Deputy Commissioner, the Superintendent of Police, the Assistant Commissioner, the CEO, and presided over by the 15th accused in his capacity as the district in charge minister. That is on 23rd April 2016. Well, that meeting was called for or summoned so that the presidents of the Taluka Panchayats and the members of the Jilla Panchayat should participate, because the chief minister was to come the very next day, so that we will be in a position to know the grievances of the villagers, and that grievance could be placed before the honorable chief minister, who is to visit on 24th of April 2016 for the ventilation or for the redressal of our grievances. But to be more precise, it was for drought management. Well, according to the prosecution, they would examine two witnesses as PWs 4 and 5. But PWs 4 and 5 were examined, saying that they went for that meeting. There was exchange of words between the deceased on the one hand and the 15th accused on the other hand, for and in connection with the question which came to be raised by the deceased in relation to the supply of water to his constituency or to his village. But PW4 is a stranger, street goer, not even a member of village panchayat, taluk panchayat, jilla panchayat. That is the evidence in the case. A street goer. I do not know how he could get into this place so that he should be made to speak about the exchange of hot words between the deceased and the 15th accused.
Can we continue tomorrow?
As my lord pleases.
Hem Kumar, you're ready, no? So I'm adjourning this. That's only one. Tomorrow we'll.
Yes. My lord, my humble request to your lordship is kindly give some priority for this. It is for this reason. It is for this reason. Recording of entire evidence is over. Tomorrow IO is going to be examined. That's all in the case. That is why, my lord, I am requesting your lordship to kindly give some priority.
Make a write-up tomorrow on the list of dates. Your narration.
I'm giving it. It is ready, madam. In fact, I shall give it. Right now, I can give it. What else?
How much more time you'll require roughly?
Because my lord wanted to know the backdrop of the matter. Otherwise, my lord, I may not take more than 10 minutes.
Without that, I couldn't have heard your 10 minutes.
So I may not take more than another 10 minutes. Well, my main grievance is 21 accused 20. Man who assaulted, man who asked him to assault, everyone is getting the benefit of bail. Why I am deprived of the benefit of bail in the case? That is all the issue here in this case. Persons against whom, my lord, the application filed by the prosecution seeking for cancellation of bail came to be granted by the trial court. And that order came to be set at naught by this honorable court. And they were allowed to continue on bail. For me, same footing, same evidence, that I influenced the witnesses. The trial court would cancel my bail. Same evidence.
What is the objections filed here by the other side?
But what they say is, even in the order also, I can read to your lordship tomorrow when my lord is going to direct me to continue my submissions further. Prosecution has got to examine two more witnesses who would speak against you. They are still to be examined. Therefore, the possibility of you meddling with them can't be ruled out. They are already examined.
That is the only substantive.
That is the only ground which they have said. Number one. Number two, as my learned friend has submitted the other day before your lordship, that the Supreme Court has cancelled the bail, and the Supreme Court has not given you the liberty to go and approach the court again for the. Well, the other day I invited your lordship's attention to the law laid down by the Supreme Court in a subsequent judgment. No such
Now,
liberty is
suppose,
there.
suppose a certain court has passed an order granting bail, and the court finds that there is violation, and bail is cancelled. So you are saying that it dies only with that court which has granted the bail, and that would not be a bar for the other court to consider.
Because subsequent events, I am asking for bail on this score that the entire evidence has been recorded. There is nothing against me. And this honorable court, my lord, in relation to three of the accused, 7, 9, and well, three of the accused, this honorable court would say on the same ground, all right, let the witnesses who are to depose in or in relation to the act said to have been done by them, let them be examined, and no sooner they're examined, they should be enlarged on bail. They were examined and enlarged on bail. That is the order of this honorable court. They were examined, discharged, they were released. A direction to the trial court to release. There is no question of consideration of their application for bail. No, that tomorrow it is announced for a examination of the investigator of the case. That's all. But the next stage is recording of statement of the accused, arguments. Why should I remain in custody, my lord, till then? Their apprehension is not on the merits of the matter. They do not say that on the merits of the matter I am entitled for the grant of the relief of bail. I had meddled with two witnesses who were even examined prior to their making the application. Doesn't matter, my lord, we can't go back.
Tomorrow we'll continue.
Whatever.
Relist the matter. The list of learned senior counsel, Sri C.V. Nagesh, has advanced arguments on behalf of the petitioner.
In fact, my lord has granted bail to 8 of the accused in this case
And
for the actual assailants.
The list of events, same is taken on record for further arguments. List tomorrow. You also get ready.
My lord, if my lord permits me, I shall place on record the bail orders passed in relation to 20 accused in the case by this court. If my lord permits me. Otherwise, it is not necessary. Because your lordship has granted bail to A17 to 14, who according to the CBI are the actual assailants of the deceased.
The compilation of orders. Regarding bail granted to co-accused is also filed. Same is taken on record. Which are those three accused whose bail was cancelled and then High Court set aside?
9,
9?
19, I'm sorry, 9, 16 and 19. Well, the trial court itself would grant bail to A16. The application is a common application against me and A16, saying only not that they have seen me meddling with the course of administration of justice. But I was in the corridor of the court, having brought from the judicial custody. I was standing there. That is the evidence. I was standing there. One person would come and prostrate, touch my legs, seeking for my blessings. I would bless him. And that person would go and talk to that witness. That witness, that person again talks to 16th accused also. Therefore, the learned judge says the possibility of you influencing that witness to turn hostile. Who is that witness? Recovery of a weapon from one of the accused who went for trial before the Dharwad court.
Tomorrow.
But would your lordship direct me to be here at any
Post
further-
lunch, post lunch.
Please, deeply, please.
27. Moment.
Open in another court. Possible, short, possible, if possible.
With great respect to your lordships, my lords,
It is.
and with this, respect to this honorable court and
Let them start, I'll hear.
lords, this petition has to be posted before roster bench, my lords, because it is filed under article 226, read with my lords, 528 of BNSS, my lords. Since specific bench is assigned with my lords, this has to go before roster bench, my lords. That is my submission.
You have a copy of the notification you have?
Lords, work allotment notification is there, my lords.
Manjunath, roster. Sitting list.
The petitions filed under article 226 read with 482. Sitting list.
In fact, my lords, I'm given to understand the colleague moved it in before that court, but then the office would say since it involves GST proceedings, it comes before this court. That's how they have posted it here.
Irrespective of my lords GST, it is a penal provision, my lords, under which my lords are taking, my lords, action is being taken.
ಇದ್ರದ್ದು ಅದು ಬೇಲ್ 482 ಆಮೇಲೆ ಕೊನೆ ಒಂದು ಫುಲ್ ಇದು ಎಲ್ಲ ಫುಲ್ ಪ್ರಿಂಟ್ಔಟ್ ತಗೊಂಡ್ಬಿಟ್ರಿ.
Whether it is GST or sales, whatever tax matter, my lords, if penal provision is invoked, it has to, my lords, come before my lords, roster bench under section 482 of, that is 528, my lords, of BNSS. Office could not have posted matter before the Honorable Court, my lords. That is my submission with respect to the honorable bench as well as
Just 226 read with 482.
528 of new within BNSS, my lords, under section 528 of BNSS. Earlier it was 482, my lords, of CRPC.
My lords is looking for the sitting list, my lords. That
Sitting
would be
list.
court hall 16. If it is 226 read with 482, would be court hall 16. My lords, in fact, it was moved like that. But the office, because it saw it to be a GST matter, would post it before this court. My lords, anyway, I'm not on that. What we feel, my lords, more aggrieved is when the matter is before this honorable court, my lords, and this honorable court has heard some portion of it and posted it at 2:30. Being fully aware, my lords, the matter is here. Could you move an application in the lower court and say we want to record this statement for 5 days, and then order is passed? There it is not even made known that the matter is pending here. At least, my lords, after having seen that the matter is pending here before this court, making that request is different. And a lady, my lords, her 2 children are here. There's no one to take care of her. Now, if it's only for the purpose of recording the statement of hers, my lords, it can be done on a day-to-day basis. She did not be in JC for that purpose, my lords. They say they don't want PC, only they want to record her statement under section 70 of the GST Act. Then it can be recorded on a day-to-day basis. Why this need of saying we will go to the Harpana Agrahara, record a statement there and come? And that too, my lords, in that application, they say for 5 days they want to keep doing this. And this court is seized of the matter, my lords. At a point of time, they'll be able to demonstrate, my lords. In cases like this, it's cases for anticipatory bail. Even the custodial interrogation is taken care of in an anticipatory bail as a condition.
Lords,
It's punishable with up to 5 years, my lords. A lady is involved. The need and necessity of arresting that lady, my lords, under the GST Act. It is not merely, my lords, similar to what we see in PMLA, my lords, section 19, which I had argued, my lords, in saying there should be some reasons to believe that they have committed the offense. Similarly, we have it under 69 here. When you record it, commissioner should be so convinced, my lords, that there's a necessity for an arrest. Here, my lords, on 3-1, you issue a summons. Summon cause an arrest. All right, you want some statements from us, record our statements. What is the necessity to arrest me and say go to JC? Not even asking for a piece. Husband is in custody, my lords. And even according to them, this entire aspect is about 18.76 is what they mention now. Our only concern is humanitarian grounds, my lords. The children now, one is 11-year-old, my lords, other is 18-year-old. To take care of their interest. And even the statements can be recorded as a condition, my lords.
Just open that sitting list in your mobile.
Yes,
We've
yes,
got
it
it
is there,
here.
my lords.
We've got it. Can I pass this on?
I'll get a printout. We'll just go through it together.
Yes.
No, I have a printout. Just open it. No, I'm getting a printout. You keep it there.
Yes.
Put it.
Well, it's court hall 8, this honorable courts, my lords. It
No,
would be
no, this is, just go to that 226, 480.
16, my lords, court hall 16.
Court hall 16, my lords.
Court hall 16.
My lords,
Let's, could I just point out criminal petition under 482 of Criminal Procedure Code, writ petition under 226 and 227 of the Constitution. Probably, my lords, now it may have to be criminal petition under 528, my lords, BNSS. No longer we have CRPC, but I think old is, it's in that manner. From 2023 onwards, admissions, orders and final hearing. 482, under 482 CRPC and writ petition under 226 and 227 of the Constitution.
Then it has to go before that bench only. But how have they classified it as a tax?
The office does it, my lords. In fact, the movement was done there, my lords, pointing out the urgency. But the office classifies it as tax because it's GST, evasion of tax. And that's how it came before this.
Now you have filed with 226, read with
Yes,
58.
my lords.
528.
528 of BNSS. That's how it's filed.
The order sheet could have.
My lords, would notice at page 1 itself, my lords, 528 of BNSS. In fact, my lords, in the office, when it was pointed out, should be under 528, they said there's no FIR here and therefore it has to come. That's how they explained and posted it.
here is a case wherein already, my lords, judicial custody has been given.
No, we're not on merits, we're only on this. Now FIR has been lodged.
Illi FIR baralla.
Procedure is-
GST ಅಂತ ಬರುತ್ತೆ.
It would be separate. The procedure is different. You won't have a quashment of an FIR. Because ultimately, my lords, it'll form a part of a complaint, similar to PMLA where a complaint is filed under 44. Here also, post the inquiry, it forms a complaint.
So you're saying it has to go before
Yes, my lords.
226, read with
Yes, my lords.
480. Then I'll direct them to place it immediately there. What else to do?
Only
You have
problem
not
is-
challenged any order of the tax.
No, my lords, what we have challenged is arrest being illegal. We have pointed out how the arrest has taken place. There was no need and necessity for such an arrest. And despite that, an arrest has taken place. And they themselves say, my lords, JC, if they wanted any police custody, they'd have asked for it. They themselves send us to judicial custody. Now, after this matter is moved and it is heard in the morning, you go file an application saying permit us to take statements under section 70 in the police station without even bringing to the notice of the in-charge court that the matter is pending consideration.
In GST, there is no police custody, my lords. Procedure of police custody, my lords, it is only JC, my lords.
If it is going to be JC and you're going to be wanting my statement, how? Because, my lords, it's held that normally in GST matters, there won't be any custodial interrogation. That is how the Supreme Court views it. Don't have custodial interrogation is what this.
Let us see, Prakash.
Quite unfortunately, we're in a position, my lords, where the children are the sufferers.
The writ petition filed under Article 226 of the Constitution of India read with section 528 of BNSS. Full stop. The petition was posted after being clarified as regards classification falling within the category of tax dash T dash RES. Full stop. The matter was taken up for hearing today. Learned additional SPP number
PP2 minutes.
2,
State Public
Shri
Prosecutor.
Vijay Majjige submitted that the roster, appropriate roster, would be the roster pertaining to writ petitions under 226 read with 482 of CRPC. That would be a different court and not the present roster. It is submitted that the relief relates only to the legality of arrest. Legality of arrest. And for setting aside of the arrest memo. And accordingly, this court may not have the roster assignment to take up the present matter. Full stop. Taking note of the objection raised, it would be appropriate after having perused the prayer and the subject matter of the writ petition that the matter be posted before the bench which has jurisdiction relating to writ petition under 226 and 227 of Constitution of India read with section 482 of Criminal Procedure Code. Full stop. If any orders are to be taken on the administrative side, registry may obtain such orders. Full stop. The order is passed taking note of the subject matter of the present petition and the objection raised by the state. Full stop. In light of matter being relating to petition seeking release from custody, registry to place matter before the appropriate bench as expeditiously as possible. So shall I say tomorrow?
Tomorrow, my lord,
Ah,
because entry
tomorrow.
date, the prayer which
That
on-
is tomorrow. This would be appropriate considering that the petitioners have sought for a release from custody. Yes.
One request could I make, my lords, if I'm not exceeding my brief, my lords, as to what transpired today. Could there be a paragraph on that? This morning, what was argued, how the application moved, my lord. Doesn't augur well, my lords. One paragraph on what transpired today, I'm not going to be asking for.
Without entering into the merits, submission of learned senior counsel appearing for the petitioner is that when the matter was moved in the interregnum, the respondent authorities have sought for police custody.
No, my
No.
lords, they sought for recording of the statement of the accused who is in JC.
They sought
that
for
would be enough.
recording of statement of the accused who is in judicial custody. Said aspect is taken note of for the purpose of factual correctness.
Please, please.
Realist.
Deeply obliged, my lords. In fact, I don't know.
Let us see.
Yes.
Yes. Just a minute.
Huh?
ಸರ್ 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 ಇದೊಂದು ಅರ್ಧ ಆಗ್ತದೆ ನನಗೆ ಗೊತ್ತಿಲ್ಲ.
ಏನ್ 17 ಡೇಟ್ ಇದ್ದಿದ್ದು? ಎಷ್ಟನೇ ಹೇಳಿ ಕೇಶವ ಭಟ್ಟ ಮುಂದಕ್ಕೆ ಹೋಗಿರುತ್ತೆ ಬೆಸ್ಟ್ ಅಪ್ಡೇಷನ್ಸ್ ಕಂಪ್ಲೀಟ್ ಮಾಡಬೇಕು. ಅಪ್ಡೇಷನ್ ಎಮರ್ಜೆನ್ಸಿ ಏನಿಲ್ಲ ಅದರಲ್ಲಿ. ಎಲ್ಲಿ 2ನೇ ತಾರೀಕು 17 ಜನವರಿ ನೀವೊಬ್ಬರೇ ಬರಬೇಕು. ಅಲ್ಲ ನೀವೊಬ್ಬರೇ ಬರಬೇಕು ಅಂದೆ. 16 ನೀವೊಬ್ಬರೇ ಬರಬೇಕು. ಕನ್ಫ್ಯೂಸ್ ಮಾಡ್ಬಿಡ್ತಾರೆ. ಅದೇ ಲೋಹಿತ್ ಸರ್ ಅಷ್ಟೇ. ಇದ್ರದ ಈ ಕಾಪಿದ ವೈಟ್ ಹೋಗ್ಬಿಟ್ಟು ನಿಮ್ಗೆ ಕೊಟ್ಬಿಟ್ಟಿರ್ತಾಳೆ. ಒಂದೇ 47 ನಾಳೆ ಹೋಗ್ಬಿಟ್ಟು ನೀವು ನಾಳೆ ಬರುತ್ತೆ ಹೋಗಿ ಪರವಾಗಿಲ್ಲ. ಸ್ಕೂಟಿನಿ ಕಳಿಸ್ಬೇಕಾಗತ್ತೆ. ಇದು ಸ್ಕೂಟಿನಿಗೆ ಹೋಗ್ಬೇಕಲ್ವಾ ಇದು? ಅಲ್ಲಿ ನೋಟಿಸ್ ಆಗತ್ತೆ. ರೋಸ್ಟರ್ ಅಂತಂದ್ರೆ ಸ್ಕೂಟಿನಿಗೆ ಕಳಿಸ್ಬೇಕು. ಸ್ಕೂಟಿನಿಗೆ ಕಳಿಸ್ತೀವಿ. ಸ್ಕೂಟಿನಿಗೆ ಒಂದು ಫೈಲ್ ಕೊಡ್ಬೇಕು ನಾಳೆ ಡೇಟಿಗೆ. ಇದೆ 8 of 46. ಎರಡು ಮ್ಯಾಟ್ರೂ ಇದೆ. ಯಾವುದು ಇವಾಗ ಇವನು ಪ್ರಕಾಶ್ ಆಯ್ತಲ್ಲ ಈಗ ಅದು ಅದಲ್ಲ ಇನ್ನೊಂದು ತಗೊಂಡು ಒಂದು ಸೆಕೆಂಡ್